Have you ever seen a legal battle so tangled that every new document feels like another plot twist? Well, the latest chapter in the Zaptor versus Aptera intellectual property saga has just landed, and it's a big one. Zaptor has officially filed its second amended complaint, and it reshapes the entire direction of this case. If you thought things were already complicated, this filing makes it clear everything is about to escalate. To understand the weight of what has just been filed, we need to rewind a little. Earlier this year, the court issued a mixed ruling on Aptera's attempt to dismiss the case entirely. Aptera had asked the court to throw everything out, arguing that the claims lacked merit. But the judge didn't agree with that assessment. Some claims were dismissed, others survived, and a few were dismissed but allowed to be amended and refiled. That brings us to this moment. The amended complaint is now here, and it attempts to fill in every gap the judge highlighted. Before this amended filing, here was the legal scorecard. Patent infringement claims survived the motion to dismiss because the court found that Zaptor's allegations were strong enough to proceed. Several claims were dismissed with leave to amend, including the trade secret misappropriation claim, declaratory judgment, and claims against individual defendants. The court essentially said, you need to provide more detail if you want these accusations to stick. Claims dismissed with prejudice, such as tortious interference, unjust enrichment, fraudulent inducement, unfair competition violations, and claims against the original Aptera LLC, are permanently gone. Fraudulent inducement was dismissed without leave to amend. So Zaptor returned with a sharpened set of allegations aimed at strengthening the claims the court left open. This new filing attempts to attach personal responsibility to several key Aptera figures. Zaptor begins with a bold statement. They say they purchased valuable intellectual property from Aptera 1 only to watch the founders launch a new version of Aptera using the same IP years later. They argue that the court already validated parts of their case by letting the design patent claims move forward. But the judge asked for more specificity. What did each individual defendant personally do? How did Zaptor protect the supposed trade secrets? And what exactly were those trade secrets? This amended complaint tries to answer all of that. And here's where things get interesting. One major issue the court raised earlier was that Zaptor lumped all defendants together. This time, they're attempting to pinpoint specific actions by specific people and establish individual liability. The new filing argues that corporate officers can be held personally liable for patent infringement, even when acting on behalf of a company. And then it lays out what each individual allegedly did. For Nathan Armstrong, the filing claims he worked closely with design leadership on materials connected to patented concepts and resumed development on aerodynamic shapes tied to Zaptor's patents. It also alleges he believed no one remained alive to enforce rights to the IP after one of the original buyers passed away, suggesting he thought the IP had become unenforceable. For Chris Anthony, Zaptor alleges that he was involved in reviving or reusing patent-covered material and resumed using elements of Zaptor's claimed IP while helping develop the newer Aptera vehicle. For Steve Folt, Zaptor claims he was aware of the prior NDA and asset transfer, and that knowledge makes his participation willful in their view. For Jason Hill, the chief of design, the filing asserts that he led the aerodynamic and aesthetic direction of Aptera's newest vehicles and knowingly carried forward design principles covered by Zaptor's patents. The most unusual allegation surrounds Michael Johnson. Despite being primarily an investor with no engineering role, Zaptor accuses him of participating in the use or ratification of the intellectual property. This accusation stands out because it's difficult to see how he fits the same pattern as the engineering-focused defendants. One of the central issues in the earlier version of the case was the trade secret claim. The court dismissed it because Zaptor never made clear what those secrets were. This time, they list them: cooling methods, process technologies, special blends of lightweight and strong materials, manufacturing methods involving proprietary honeycomb structures, and design formulas for aerodynamic efficiency. However, this is also where parts of Zaptor's argument weaken. Aptera hasn't used the honeycomb composite method in years. They transitioned to entirely different manufacturing techniques involving SMC and CFC SMC. So Zaptor's portrayal of Aptera's materials and methods doesn't align with the company's current reality. That discrepancy could undercut parts of their argument. They also describe the aerodynamic shape as a trade secret. But aerodynamic designs are based on physics and decades of published aerodynamic research. The idea of a car's shape being a trade secret is hard to defend legally. One of the more dramatic allegations is the claim that after one of the original IP purchasers passed away, some Aptera figures believed there was no one left who could enforce those rights. According to Zaptor, that belief led them to continue using elements of the old designs. Again, it's an allegation, not a proven fact, but it's a major point in Zaptor's narrative. Now that the amended complaint has been filed, Aptera will respond. They will almost certainly deny most of, if not all of the allegations, challenge the accuracy of the claims, and argue that the trade secrets are outdated, not protectable, or simply incorrect. The bigger question is whether the judge will dismiss any remaining claims. Given the court's earlier approach, it seems unlikely that everything will be dismissed. The patent claims already survived once, and this new filing includes enough detail that the trade secret and individual liability claims may survive long enough to enter the next phase of litigation. And that next phase is discovery. This is where both sides exchange documents, gather evidence, conduct depositions, consult experts, and reveal internal communications. It's the stage where speculation turns into concrete factual evidence. Discovery can take months or even years, and given how committed both sides appear to be, an early settlement seems unlikely. This legal battle is nowhere near its end. If anything, this second amended complaint shows that Zaptor intends to push forward aggressively. Aptera will respond just as forcefully. The court will decide which claims survive, and then the long, technical, evidence-heavy discovery phase will begin. There are still far more questions than answers, and this case will continue shaping the conversation for a long time. What do you think will happen next? This story is only beginning to unfold.